charged with 2 cases. You were charged with criminal trespass. You're also charged with criminal mischief. On both of those, you're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement. They're offering you 48 days in jail with credit for the 16 that you've done on the criminal trespass. They're dismissing the other case?
Yes, Your Honor. Time served on the criminal trespass and dismissing criminal mischief.
Is this how you understand it, sir?
Yes.
You need to understand also that this charge will go on your record. You're now facing a minimum of 30 days in jail for any new cases that you pick up. You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. Like I said, you give up the right to appeal. So once you plead guilty, it stays on your record. Is this what you want to do?
Yeah, I believe so.
How do you plead? How do you plead to the offense, sir? Guilty.
I plead guilty.
All right. I'm going to find you guilty. I'll follow the agreement. Good luck to you, sir.
What about the enhancement?
Abandonment.
Yeah.
Or wait a second. Is it listed as?
It's listed as.
Okay. Hold on. Hold on.
Yes.
He's got to. Is it true or come up, Mr. LZ? Is it true or untrue that you had a prior terroristic threat, sir?
And here's the curveball. Just when the defendant thought his deal was solid, the court dug up his past, a prior terroristic threat. That's not just baggage, it's a bombshell. Judges don't overlook history, and it can change a sentencing decision in an instant.
I'm on my medication, so I missed my medication. I had trouble getting my medication. I was just...
Did you have a prior terroristic threat in the past? It looks like from August of this past year with us.
I don't remember any terroristic threat towards you guys?
No, just in general.
You had a case in this court that you took 57 days time on, and that was August 20th of 2024. Do you remember taking that plea bargain?
I believe I was in court before, but
That's all we need to know. That's it. Okay. All right. Thank you. I don't know if we found probable cause on this first case? Or on the new case? Let me express my extreme disappointment, Mr. Guevara Ortiz. You now stand charged with yet another DWI. On this one, you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
Yes, Judge. On January 19th, 2025 at 11:43 p.m., the officer was dispatched due to a concerned citizen following a possible intoxicated driver. The call was near Northborough in Houston County, Harris County, Texas. The officer arrived at a public place and observed the defendant, the driver, and sole occupant of the vehicle.
This is where the evidence stacks up like bricks. Bloodshot eyes, slow reactions, a failed sobriety test, and then the knockout blow. A breathalyzer reading of .177, more than double the legal limit. At that point, folks, even the best defense attorney has little room to maneuver.
And the witness stated the defendant was observed to have severe damage to the front passenger side, and he struggled to stay in its lane several times. The witness had eyes on the defendant until the officer arrived, and the officer made contact with the defendant, who advised that he had 3 Coronas and was coming from a gas station where he purchased the beers while driving home.
So drinking while?
No, Your Honor, there's no indication of that. He just purchased while driving home. And the officer observed glossy eyes, delayed responses, and a strong odor of an alcoholic beverage. The officer conducted standard field sobriety tests, HGN 6 out of 6. The defendant refused the walk and turn and one-leg stand due to the cold temperatures. The defendant was read the DIC and consented to breath. The results were .189 and .177.
Mr. Guevara Ortiz, I'm going to find that there's enough probable cause to go forward with your case, and I am now going to revoke your bond on your first case, and I'm going to set it at 10,001. You now also have an immigration detainer, so you'll be stuck in there, I guess, until
Two monitors strapped to his ankles. One tracking GPS, the other detecting alcohol. That's double surveillance in real time. Think of it as a constant reminder. One wrong move and the court knows instantly. It's parole with a digital leash.
I need to know, counsel, if you guys are planning on trying to get him an immigration bond or not.
Your Honor, we don't represent him on the immigration case, but it's my understanding from Mr. Breston that there's an effort to address that.
Okay. You're signing on for Mr. Breston now, right?
Yeah, I work for him. Yes, sir.
Got it. All right. Mr. Guevara Ortiz, I'm now ordering you to have an ankle monitor on your ankle, and I'm giving you a curfew of 7 p.m. to 7 a.m. I'm going to put a scram ankle monitor on you so I know that you're not consuming alcohol. On your other ankle, you will get a GPS monitor. I don't know if you're getting out of custody, but if you do get out of custody, these will be your bond conditions. You will have on one ankle, like I said, a scram monitor so I know that you're not consuming alcohol. On your other, you will get a GPS monitor so I know that you're abiding by curfew. Do you understand?
Yes.
Okay, so I guess we'll set you out for 30 days. Just keep us in the loop. If you are able to get an immigration bond, you must be here the next business day. If you fail to do so, I'm going to revoke both of your bonds and set them extremely high. Do you understand?
Yes.
Okay, all right.
Thank you, Your Honor.
Thank you, sir. Okay, so tell me what's going on.
Dave's asking for extension.
So this one for Sims, we're asking for an extension from Mississippi for a probation violation for malicious mischief. Obviously, due to Winter Storm Enzo, they're requesting extension because the airports were literally closed.
Get ready, we're gonna get so many of these, you know?
Oh.
Let's get ready.
Yeah, they're coming.
And so this one, they're requesting out to the 27th. The 28th. They'll pick up on the 27th, but because even with when they were originally supposed to come on the 21st, it wrapped around the weekend. That's why we're entering the pre-signed waiver. Ricardo is opposed, which is why I'm entering it.
Okay, I mean, I have to, circumstances beyond, act of God, right? As they say.
Judge, of course, I gotta be opposed. I gotta fight for my client. His expectation was to get out at a certain day, through no fault of his own. He's gotta be here an extra 7 days, looks like. He doesn't control the weather. Nobody does.
Is it 7?
It's because the original pickup date was the 21st. Well, so the 21st, and then the court reset date would be the 28th. They're looking to pick them up on the 27th.
Just get a little bit less than a week. Understand that there is an act of God, right? That just completely close everything. You get just one kernel of snow, the entire city shuts down. So I'm going to grant them an extension. You're not going to get another one.
I have to ask Judge.
So understand, Mr. Kim, that I don't.
They had like 13 days before the snow. That's what I'm saying. Why didn't they come in?
Well, I can't answer that. I mean, that's something.
Oh, yeah.
Judge, I would ask, would you consider, giving him a bond so he could go turn himself in and not have to wait 7 days? That's what we said.
For the pre-signed
It's
waiver.
a pre-signed waiver. I
Pre-signed
can't
waiver,
give
he's
them a
not
bond.
allowed.
Understood.
Yeah, I mean, you got to understand when you get on probation or when you get on parole in another state, you sign conditions. One of those conditions is that if you ever take off and you become a fugitive, you waive extradition. It's a pre-signed waiver. You have already waived by virtue of signing. You need to read every single thing when you sign it, all the little print, because even if I wanted to give you a bond, I can't because you have already waived by signing that document.
Judge, if for some reason they don't make it by this deadline, will he be getting out?
That's a great question. Mr. Kim?
Actually, with the I got to look at the original waiver date. So it's 5th. So statutorily, they have until February 4th, 2025. So strictly speaking, for the pre-signed waiver, he's not allowed to. But this is one where they've already confirmed they're coming on the 27th. So I think it will be a distinction without a difference because they've already scheduled for him to come on the 27th, unless we get another once in a lifetime storm.
So we're gonna give him until the 4th is what I'm hearing?
Well, the recess is gonna be 28th.
28th.
That's not one.
You already indicated they're coming on the 27th.
I mean, act of God.
I don't see anything happening between now and then. Otherwise, the news would be just going nuts, you know?
All right,
Yeah.
well,
I mean, should something happen, we'll cross that bridge when we get there.
we're back up here.
They've said that they're going to come get you absolutely on the 27th. I don't know what time, but on that
I'll
day.
confirm with them that we approached and then submit the order and triple check today that that is still the confirmed date, because obviously we've had ones in the past where we confirmed too late and they had to move it. So I'm going to triple check today.
And he'll let you know.
I'll talk to them.
Okay.
Thank you, Judge.
We'll talk some more. Mr.
So you were charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement where they're offering you 3 days in jail with credit for the 2 days that you've done. You need to understand that this charge will go on your record. It's going to be there for the rest of your life. From now on, you are facing a minimum of 30 days in jail. No more proverbial slaps on the wrist. Do you understand?
Yes.
If you get pulled
Sí,
over,
usted lo paga.
first thing an officer does is they look up your criminal history. If they see prior DWIs and they come up to you and say, smell alcohol, it's probably not going to go well. So from now forth, I would never, even if you had a sip of alcohol, get into a car. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, you can never take this off. Do you understand? This is what you want to do.
Yes, sir? Yes.
How do you plead to the offense of driving while intoxicated? Guilty or not guilty?
O no culpable. Guilty.
I will find you guilty. I want to send you to the agreement. Let me make one more thing clear, Mr. Espinoza. There is a $3,000 surcharge on this type of case. You pick up a DWI second, it's a $6,000 surcharge on your case that you can probably end up paying. I will waive it now, but understand, if you continue to put other people's lives in danger, it's not going to go well for you.
Muy bien.
Good luck, sir.
Buena suerte, señor.
Thank you.
Now things get legally intense. The whole fight comes down to timing. Was the gun actually on him while committing the crime? The defense says it was just talk, no action yet. The prosecution fires back. Once the offer was made, that loaded gun in the car counts. This is the clash of statutes, safety, and strategy.
Can we approach on something? I'd like you to hear probable cause and something.
Absolutely.
You have it pulled up?
Oh, yes, sir.
Okay.
So it's for Klaba. Okay. On January 15th at approximately 6 p.m., officers initiated a reverse prostitution investigation. Undercover officer saw defendant parked near where she was standing. Defendant rolled down his driver's side window. Officers approached the defendant and had a conversation sexual in nature. Defendant agreed to engage in sexual intercourse with the officer in exchange for $100. Defendant and officer arranged to meet at a motel. Defendant started driving in the direction of the motel. Defendant was then stopped and identified by marked units. During this, officers located a loaded firearm behind the front passenger seat. During the search incident, sorry.
So it would have been my argument is that the possession of the gun was not while he was engaged in this alleged criminal activity.
And we would understand where he's coming from, Your Honor. However, he did have the loaded firearm behind the front passenger seat, and this was search incident to arrest. So that's where we would be at.
We have the unusual circumstance here of my client is an aircraft mechanic. He works over at IAH. As a result of the gun case, not the solicitation case, the gun case, he lost his job. He can get it back because he's a member of the union. But the gun case is the only problem because he was charged with a gun. He lost his job. Now, I assume we're going to be able to work out the solicitation case with the stand.
I mean, I'm sure would probably work out in conjunction as well, you know? I mean, it's,
So, but in the meantime, we can't work. So,
let me read the statute. Hold on.
That one will have to finish ours. Oh, what if he's one of the seats? I can't do this.
I tried to replace my plumbing, but I forgot to shut off the water. It's been blew out. All you gotta do is glue stuff.
So I'm looking at 46.02. Unlawful carrying of a weapon. A person commits an offense if the person, one, intentionally, knowingly, or recklessly carries on or about his or her person a handgun at the time of the offense. So is this at the time of the offense? Right? I guess there lies the question.
He was proceeding to the motel where the incident, that they agreed to would occur. So during the process,
So, because, I mean, the offense is committed when? When the actually agreement took place.
requires the way the charge reads, it requires, the offense is complete at the time that an agreement is
Reached.
made. So,
The agreement is made at the time, allegedly, when they're stopped. They had the wherewithal, if they wanted to, arrest him at that time, where subject to arrest at that time, they could have made the charge, so to speak, right? But they decided to wait.
Well, Your Honor, if I may, the statute reads they had honor about his person while committing criminal activity, and the firearm was in the vehicle while the offer was being made. It was just on the way to the hotel or the motel is when they stopped him and search incident to arrest for that solicitation. That's when they found the firearm. But the firearm was on or about the defendant's person while he was engaged in the offer for the solicitation.
And also, if I may, Judge, I would also say it would make sense for safety procedures for them to make the arrest while he was on the way to the motel so that they could have followed him and it wasn't just that undercover officer there at the scene and making the arrest.
No, I don't know, because they could have arrested him at the time, right on the spot. I don't know why they would try to bolster the case, I guess, by saying that there's more evidence of guilt by actually going to the motel. I mean, theoretically, they could have arrested at the time that the agreement is made, right? It's a contract.
Judge, I think we would just stick to the way the statute is worded is while engaged and the firearm was there. And they could have arrested him earlier, but as Mackenzie knows, they do that routinely for safety purposes as well as perhaps as you mentioned, they could have done it for further evidence as well, further investigation.
Prostitution cases I've seen is they arrest right on the spot, right then and there. They don't wait. I mean, the offense occurs right then and there.
And the offense did occur and while the defendant was in the vehicle, that's when the offense occurred. He was in the vehicle when they made that agreement and the firearm was in the vehicle. They found it right after they followed him to the motel. It was in the same transaction.
the offense was
I can't
complete.
believe
I agree with you. I'll find no problem calls.